Start. What is held by this court is that a purposive interpretation should be made of Section 148 of the NI Act. Full stop. Hence, normally, appellate court will be justified in imposing the condition of deposit as provided in Section 148. Full stop. However, in a case where the appellate court is satisfied that the condition of deposit of 20% will be unjust or imposing such a condition will amount to deprivation of the right of appeal of the appellant, exception can be made for the reasons specifically recorded. Full stop. Therefore, when appellate court considers the prayer under section 389 of the CRPC of an accused who has been convicted for offence under section 138 of the NI Act, it is always open for the appellate court to consider whether it is an exceptional case which warrants grant of suspension of the sentence without imposing the condition of deposit of 20% of the fine slash compensation amount. Full stop. As stated earlier, if the appellate court comes to the conclusion that it is an exceptional case, the reasons for coming to the said conclusion must be recorded. Full stop. The submission of the learned counsel appearing for the original complainant is that neither before the sessions court nor before the high court, there was a plea made by the appellants that an exception may be made in these cases and the requirement of deposit or minimum 20% of the amount be dispensed with. Full stop. He submits that if such a prayer was not made by the appellants, there were no reasons for the courts to consider the said plea. Full stop. We disagree with the above submission. Full stop. When an accused applies under section 389 of the CRPC for suspension of sentence, he normally applies for grant of relief of suspension of sentence without any condition. Full stop. Therefore, when a blanket order is sought by the appellants, the court has to consider whether the case falls in exception or not. Full stop. In these cases, both the sessions courts and the high court have proceeded on the erroneous premise that deposit of minimum 20% amount is an absolute rule which does not accommodate any exception. Full stop. The learned counsel appearing for the appellants, at this stage, states that the appellants have deposited 20% of the compensation amount. Full stop. However, this is the matter to be examined by the High Court. Full stop. In these circumstances, we set aside the impugned orders of the High Court and restore the revision petitions. Full stop. We direct the parties to appear before the roster bench of the High Court on 9/10/2023 in the morning to enable the High Court to fix a date for hearing of the revision petitions. Full stop. As the contesting parties are before the court, it will not be necessary for the High Court to issue a notice of the date fixed for hearing. Full stop. The High Court, after hearing the parties, will consider whether 20% of the amount is already deposited or not. Full stop. If the court comes to the conclusion that 20% of the amount is not deposited, the court will re-examine the revision petitions. Full stop.